Let's get into talking about the use and disclosure of personal health information. Right. One of the things to pay attention to as a healthcare provider, a healthcare professional provider, is to understand that one of our responsibilities is to safeguard sensitive information. And the little note says do not use patient's name when talking to newspaper. But a rule of thumb is to do not use patient's name when talking about the patient in any way, even if the patient has already said you it's okay for you to talk about me. Regardless, you still have a professional responsibility to, as much as possible, protect the patient's privacy as much as you can. But in addition to that, a couple of other things to do is not to leave documents that may contain PHIs or in places that may be unattended, especially if it's a place that is, open to multiple users, that different people come and go. Things like the fax machines, printers, and copiers. Kind of those places that there may be many unauthorized persons, and it's going to be very difficult to trace back who may have seen it or who did not see it. Other things to do is kind of do not, don't allow removal of documents that potentially have PHIs without, some authorization or whatever appropriate security measure has been put in place in that organization, in that facility. One of the things that new hires are taught during orientation is whatever security requirements in terms of disposing patient information, or even in the handling of patient information. So this is something you kind of want to pay extra attention to, so that you do not, mistakenly or unintentionally cause data breach. So it's something to pay attention to. Thirdly, is when it comes to storing portable media, that could be USB, it could be a recorder, or whatever device that may potentially contain PHIs, is to put it in a locked drawer. This is even if you have a USB that is password protected, you still kind of want to put the extra security measure by putting it in a locked drawer. It's also the same as when you have a hard copy of info items that may contain personal health information, also to put them in locked drawers, even if the office itself is, has a lock and is always locked. Still want to put it in a locked drawer. We're going to talk about written authorization, because that's, comes with disclosure of PHI. I included a link that kind of defines what written authorization is, but in a nutshell, it's more or less like what a patient says, that says this is fine, this is who you can share my health information to, this is who you can disclose my health information to, all of those things. Some of the times they are not like documents that the patient draws out. Some of the times, a lot of the times, those are all part of the documents that they make you sign when you go to the hospital. During check-in, they'll tell you, whether you, approve this and this and that. Those are all part of the written authorization. So under the written authorization, one of the things that you could be authorizing is to say it's okay to share my PHI with friends and family, even if they are not my medical power of attorney. Power of attorney is someone you say this person can take medical decisions on my, take medical decisions for me on my behalf. So that's what a medical power of attorney is. Your written authorization is saying, even if this person is not a medical power of attorney, it is fine to share this information with this person. And also to say, this is fine if you disclose my information to a pharmaceutical company. It is fine if, let's say, there's a lawsuit and the lawyer says, I want to see this patient's medical records, to say this is fine to disclose that. or also, whether it's fine to share it with insurance companies who may be trying to determine what your premium payment is going to be and stuff like that. Or if you wish to, there's a need for determining disability, you could say this is what I'm okay with and this is what I'm not okay with. Also saying this is whether you're okay with having your information used for data, used for research and other studies that may be carried out. We are going to talk about this last bit a little bit in details in shortly. So, as all part of what information you can disclose, patient information you can disclose to their families and friends, is has to be identified by the patient. So the patient says, "This is who I have identified to be involved in my care, or this is who I've identified to be involved in payment, and this is the kind of information that I'm okay with this person knowing." Which also at the very root of it is the patient saying, I have agreed to this disclosure. So disclosing, but even as healthcare providers, you want to be very careful that you're only disclosing the PHI that has been directly um, relevant to the involvement of the family or friend. Don't go telling information that is outside the family or friends involvement, or even in their care or in the payment, even if the patient has not specifically stated this is what you can disclose to this particular family. You also kind of want to use your judgment to make sure that you're only disclosing that which is directly relevant, and not, to kind of give that person the whole patient history. Just kind of want to stay as close as possible within the bounds of the things that are directly relevant to that. There are other things that also you will kind of require professional judgment in deciding what to disclose, especially in cases of emergency or where a patient is unable to express agreement or consent to anything or into any form of written authorization. You may, it may be okay to disclose a person's location, what their general condition is, in terms of whether they're lucid or not, and stuff like that. In maybe in the case of deaths, who to notify or who to identify or locate a family member or personal representative of the patient. So you use your professional judgment to decide what is okay to disclose and what is okay not to disclose in things like that. Other things that we could get into in what the patient can disclose is in terms of what they're marketing, who you're disclosing marketing information to. In terms of fundraising, the patient will say, this is what I'm okay, this information going in terms of fundraising. But when it comes to releasing some sensitive information, such as, let's say, HIV test, which unfortunately still is stigmatized, and substance abuse, mental health, developmental disabilities, those you may treat with a little bit more sensitivity than, let's say, disclosing whether a patient got vaccinated or not. Understand, that sort of thing. So with those kind of information, you kind of want to make sure that there's express consent that's been given, that it is fine to send this, because if there is any breach with this sort of information, the consequence on the patient is a little bit more severe compared to other protected health information. So you kind of want to pay a little bit closer attention when it comes to how you are releasing or sharing this information. Something to also pay attention to in terms of, now you've stored the PHI, and you have used and disclosed it. We need to also pay attention to how you're disposing of sensitive information. So there's a lot of information that is being generated on a daily basis in the healthcare system. So as you can imagine, it is impossible to store every one of this in perpetuity. You kind of at some point have to delete a couple of things. How or when you delete it is usually determined either by a law or regulation, or it could be organizational policy to say this is when it's okay to delete this information, and this is how this information should be deleted and stuff like that. But this is all the things that are all covered under, when we are talking about data privacy. So some of the things that could be done, this is not limited to all of this, is that paper records should be shredded. But it's not just about being shredded. You also want to make sure that it's being disposed in such a way that it cannot be reconstructed. We see this happen in movies. You see where you have sometimes FBI agents or CIA agents going into people's trash and digging through everything. And even when papers have been shredded or torn apart, they may just take everything and then they kind of pieced together with tapes and everything, and before you know it, a whole paper containing very important information is all reassembled and stuff like that. So this is, in that sense, that even when you're disposing this sensitive information, do it in such a way that it makes it really difficult to be reconstructed. And then things like pill bottles or patient care items with labels that usually contain patient information should be destroyed. A lot of the times, pharmacists will tell you to bring the bottles to them and then they're going to destroy it. But the honest truth is that patients do not do a really fantastic job of doing that bits by themselves. And I say this as someone who's 1,000% guilty. I have thrown away my pill bottles in the trash, and this is even knowing all the things that I know. So some of the times, patients themselves are the ones who are kind of opening themselves to data breaches, but it's even something to kind of pay attention to. That when you're talking to your patients, you also remind them that while we are going to take extra care to destroy your sensitive information, we also want you to do the same for your own disposal. So this includes, don't use the recycle bin or even the garbage can in general, and try to emphasize it as much as possible. Some of the times, the patient doesn't quite do that, and I'm saying this as someone who's 1,000% guilty of it. But regardless, we still want to make sure that we keep reminding patients that this is what needs to be done. And then electronic media, such as that may contain PHIs, must also be cleared. When you're disposing it, is sometimes it's not just enough to delete it. You kind of want to go to the garbage can, whatever, and clean it off there. This place where they tell you delete forever, that sort of thing. You want to go through there so that it's not possible to go back and pick it right up. Of course, when you are storing in the cloud, you know that you're not just deleting on the device that the information is stored in. You have to go to the cloud and also clean it up, and in such a way that it can't be retrieved when it's plugged back into the network. Another thing to do is to overwrite the information. It kind of erases the old information when you override it with new data that does not contain PHIs. You could also destroy the media itself. Also, this also very limited. You have to pay attention for those information that is backed up in the cloud. Destroying the device itself does not necessarily mean that you have safely disposed of the information, because if it's in the cloud, another device can retrieve it. So just something to kind of remember. So at the end of the day, the most important thing is so that any information that has been destroyed, it cannot be retrieved. So that is the whole aim of all of this steps that is being taken in terms of disposing PHIs. So with research, that is all part of the thing that comes with data protection. How is data used in research? One of the things that governs data use or PHIs use is the Institutional Review Board, IRB. The IRB oversees how participants' information is to be used. This includes even in terms of secondary data, which I'll talk about in a bit. It oversees how this patient information is used, how it will be disclosed, if it has to do with research purposes. So most research institutions, including higher education, like the Southeastern has its own IRB. They oversee all studies, all research studies that are done under its organization. So they kind of make sure that, and all they're looking at is to make sure that there's been adequate steps taken in protecting the use and disclosure of PHIs. But IRB can approve waivers in depending on it, and some of the areas in which IRB provides waiver. It could decide if an information is completely de-identified, then it's fine. There could be a waiver. There's not an extra step that needs to be taken in terms of protecting the patient's privacy information. De-identified is saying that it can't be, in terms of de-identified, saying it's not able to trace it back to the individual who owns that information. So that's what it means. If it's de-identified, you can't trace it back. And another thing that IRB may provide a waiver for, if it is partially de-identified, but it's put as a limited data set, and the recipient of the information signs some kind of data use agreement in terms of protecting the privacy of the information. And this can happen in terms of AI, in deciding how is patient information being used in AI development and stuff like that. So, but the IRB makes that decisions usually on a case-by-case basis, and seeing all the information that the researchers have presented before it, and saying this is the study we want to do and this is how we want to use the study. The IRB can decide, okay, whether we're approving a waiver, or you're going to have to go through the whole shebang of saying, I'm going to do A, B, C, D, E, and F to protect our patient's information. So when it comes to secondary data, um, you, as researchers, or even everybody who has privy to secondary data, we still have to respect the local regulations and the desires of patients, as it has to do with how their data is to be used in in secondary research, which is to say that the informed consent that patients give is not just in terms of disclosure to family or disclosure to legal system. It also includes whether they are okay with their data being used in form of research, even if it's to be de-identified. So that's all part of what informed consent does. So this is to say that under HIPAA, a patient can say that they don't want their information to be used in research. They don't want to participate in research, and they, even if the research is going to use their de-identified data and is going to be aggregated, they say, I don't want that. I'm not okay with that. In situations like this, the medical provider is compelled by law to remove the patient's record from their analytic database, so that this way it's not able to put it in such a format that secondary researchers can retrieve that information. So that patient's PHI will be removed or redacted, so that secondary researchers are not able to get access to it. So while the analytical databases is de-identifying patient records, it will redact some of the patient data that patients have said they don't want it to be included or to participate in secondary data or in data of any form. So that is how that bit goes. So this is where we stop with this second learning objectives. I'm going to do the last video that focuses on the third learning objectives, in which we're going to talk about the laws and regulations that protect data security. See you in a bit. Bye.